Hi, I'm Kerry Brooks. I'm talking to you today from my COVID-19 lockdown studio in my home. I hope you don't mind. I realize that it's impractical to think about doing a live presentation in front of an audience anytime soon. So I've decided to create a number of video presentations on different patent law topics, techniques, and strategies. In this series of video presentations, I'll be discussing the topic of disavowal of claim scope. Now, the job of construing patent claims can't be done in a vacuum. You must consider other things, including the written description and the patent file history, both of which can give rise to a disavowal of claim scope. My videos covering the individual cases will give you greater insight into the different things that can create a disavowal, but I'll be talking generally about a disavowal of claim scope in this introductory video presentation. Now, a disavowal of claim scope must be clear and unmistakable, but a single declarative sentence, the most common sentence in the English language, can do it. Often these sentences include verbs indicative of definiteness compared to verbs indicative of a possibility or possibilities. Other elements of grammar, including but not limited to transitional phrases, adjective phrases, conjunctions, disjunctions, and more can give rise to a disavowal. Now, a disavowal can be expressed or implied. It can be directed to a single term in a specific claim, or it doesn't have to be directed to a specific claim term, but can be applied to the claim generally, but to a specific claim, or to all the claims in a patent, or to all the claims in a patent family. It can even be applied to unrelated patents that have at least one common sentence that creates the disavowal. Unfortunately, the language that the courts use to discuss this topic is confusing. Sometimes they refer to a disavowal, a disclaimer, a global statement, and unfortunately, sometimes to an estoppel. But in any event, they're really talking about a disavowal of claim scope. But more importantly, and more helpful to you might be that if I give you my opinion on the two different categories that a disavowal of claim scope falls into. The first category is a disavowal that excludes from the claim scope that which is specified. The second category is a disavowal that limits the scope of the claims to that which is specified. Take, for example, a claim that recites a vehicle comprising a body for transporting cargo or a passenger. Now that claim's open-ended. The vehicle could be anything, provided that it includes a body for transporting cargo or a passenger. But you can create a disavowal that excludes from the scope of the claims automobiles, or you can create a disavowal that limits the scope of the claims to only automobiles. Again, quite often these disavowals are related to sentence structure or elements of grammar, but other things can create them. Well, whether you're involved in patent prep or prosecution, litigation strategy, designing around patents, or writing opinions, you should ask yourself often regarding every sentence at issue. First, does this exclude something from the scope of the claims? And second, does this limit the scope of the claims to something? Now, a disavowal of claim scope made during prosecution can be fixed or corrected, but there's a time issue with that, and there's a certain way that you have to go about doing it. And even if you do, a potential defendant could have developed intervening rights in the meantime. In my opinion, a disavowal that's in the patent application as written cannot be fixed or corrected, because doing so would create new matter. It's taking something out of the patent, or it's changing the meaning of the words in the patent to something completely different. Well, a patentee could prevail in litigation on this topic, but you're likely to spend a substantial amount of money litigating the issue of a potential disavowal of claim scope. You also might reduce your licensing negotiating power by the uncertainty caused by a potential disavowal. Or you might make it simply easy for competitors to design around your patent, or your family of patents, or perhaps even your entire patent portfolio. Or you might make it easy for competitors to render opinions of non-infringement. Now, there are over 100 cases in this area, and if you study them the way that I have, you'll have plenty of aha moments. You'll be able to spot red flags based upon the things we're going to talk about in the individual cases that a disavowal may have occurred. In fact, you'll be spotting disavowals of claim scope everywhere. In reality, they're quite rampant, widespread in the practice. But the first step to better understanding disavowals, avoiding them, and exploiting them is covered in my next video. Mean what you say and say what you mean. I hope you'll take time to listen to and watch that video, as well as the follow-up videos on the individual cases. Well, thank you for listening to this video presentation, and I hope that you found it helpful.